Thank you, Mr. Chairman, and I'd be remiss if I didn't take exception to calling the NRA members, the millions of them, radicals. I think that's an offensive statement beneath contempt in this committee. Mr. Attorney General, will you agree to come before the Oversight Committee without the need for a subpoena in the January timeframe? I will not. Mr. Attorney General, will you agree to come before the committee I chair, the Oversight Committee, the one you've produced these documents to, in the January timeframe without the need for a subpoena?
I will consider it, but I will note I've testified on four occasions with regard to this matter. I've appeared before you at least on 2 occasions.
You've appeared before this committee. Your organization pushed back on the request for a joint hearing here today. Not will you consider it, but do I need to serve a subpoena on yourself and Lanny Breuer and the other people under direct investigation of my committee, or will you agree to come voluntarily in the January timeframe before the committee?
I will consider any request that you make.
I thank you, Mr. Attorney General. I now would go to the questions of emails. This is the documents you refer to. Most of these documents, 5,000 or so, are in fact emails. Mr. Attorney General, I have a question for you. Not one of these emails, in fact, is yours. Aren't you a prolific emailer?
No.
Don't you email?
Yes.
Do you have a personal email account, and as well as an Attorney General's email account?
I have an email account at the Justice Department, yes.
Do you have a personal email?
Yes.
Do you regularly email to Lanny Breuer, your former partner, and your head of criminal division?
No, I wouldn't say regularly. There are only a limited number of people who know my email address in the Justice Department.
Well, let me cut to the chase. Don't you think it's a little conspicuous in his absence that there's not one email to or from you related to Fast and Furious in any way, shape, or form?
There are a variety of reasons why the emails that we have shared with you are there. We have shared in an unprecedented way email information that no Justice Department, no Attorney General has ever authorized before. You have deliberative information contained, I guess, in
But isn't it true that executive privilege does not flow to the Attorney General, only to the Office of the President? So deliberative process within your department, running law enforcement, in fact, doesn't serve executive privilege. As the chairman said going on, you haven't cited any reason that these would not have been delivered.
In making production determinations, we have followed what attorneys general in the past have always used as applicable standards, and these are Republican as well as Democratic attorneys general, and the information that we have provided to you has been responsive, has been, I think, fulsome, and also has been unprecedented.
Well, unprecedented would be an attorney general who knew nothing about something where his own DAG, now his present chief of staff, was intimately familiar. Gary Grindler was well aware, according to documents provided, of Fast and Furious on March 12, 2010. Are you aware of that? That he was aware of Fast and Furious and what its procedures were on March of 2010?
It was certainly brought to his attention as part of a regular briefing that he got from ATF, but he did not hear during that briefing anything about the tactics.
Really? Is that why in his own handwriting, when he talks about going to stash houses, he clearly understood in a document you've delivered, he clearly understood in his own handwriting what the tactic was. I'm sorry, but I'm going to ask you a different question.
Well,
because he understood. No. Look,
can I answer that question?
You've answered it less than truthfully.
Chairman, could the questioner allow the witness to answer the
Madam,
question?
this is my time. I am not yielding.
I'm not asking to yield. I'd appreciate it.
The gentleman from California,
if you would
Mr.
allow the
Issa, has the
witness to
time.
answer the question.
The gentleman from California, Mr. Issa,
I understand
has the
that.
time. The gentlewoman from Texas has
I'd
not been
appreciate it if the
recognized.
witness could be allowed to answer the question, Mr. Chairman.
The gentleman from Texas has not been recognized.
I ask
for
a sense of protocol here.
The gentleman from California has the time.
Mr. Attorney General, as I was saying, Mr. Grindler, you can't answer on his behalf, and so it makes no sense to. This is evidence that was delivered. Do you regularly talk to your chief of staff, and do you regularly receive oral briefings from Mr. Grindler? And in fact, when you made the decision to have him be the DAG and then the chief of staff, wouldn't it be reasonable to assume that if he knew on March 10th, as this document indicates, that you would also know? March 10th, March of 2010, March 12th of 2010.
Well, first, he was not made intimately familiar with the program as a result of that briefing. The briefing that he received from then Acting Director Melson did not go into the tactics. Melson indicated—
Of course it didn't go into the tactics. Mr. Chairman, I'd ask that I have the time restored that I lost with the lady's interruption.
The gentleman is recognized for an additional minute, and also to give the opportunity to the Attorney General to respond to the
I
question.
certainly look forward to that. Mr. Attorney General.
I was in the middle of an answer, I think.
You know, you're in the middle of filibustering, so I'll let you answer. I have two more things to quickly go over, and then you can have all the time the chairman will give you. Does it surprise you that these boxes, 5 boxes, represent just what one gun dealer gave us voluntarily? Well, in fact, this seems to be all the information you have responsive to our subpoena. Does it cause you to think that, in fact, we believe you were withholding documents? We believe that, in fact, there is more production. So my final question, and you can answer all of them for as long as the chairman wants, is do you today have documents responsive to the lawful request of the Oversight Committee that have not yet been granted?
All right, well, let me go back to my first answer that I was not—
Well, mine's pretty easy. Mine's a yes or no, and then the others you're going to go on for a while.
I'll get to that.
Would you please get to it first?
With regard to Gary Grindler, he was not provided with a detailed analysis of Fast and Furious. He was given information about
Mr. Chairman, I asked earlier that the Attorney General be placed under oath. I was denied that. But what I will make the point is that it is not productive for anyone to come before this committee and tell us what somebody else didn't know. That is exactly how the legislative liaison behind the Attorney General, Mr. Weish, came and gave false testimony to my committee. False because people who are still working for the Attorney General knowingly gave him misleading information in addition to the U.S. Attorney, and no action has been taken.
Is the gentleman's time been extended, or is there regular order?
I'm speaking to the chairman. I might note for the record that the IG—
I have a parliamentary inquiry, Mr. Chairman.
The gentleman—
I have a parliamentary inquiry, Mr. Chairman.
The gentleman from California continues to be recognized, and let me make a point in the record that he is not over time near as much as the gentlewoman from Texas was a few minutes ago. So let's
I thank you
give
for
him
your
equal
courtesy,
respect.
but I would like to understand whether the gentleman has extended time.
And he was recognized for that purpose, as the Attorney General will be recognized for the purpose of responding to
And
the
will
question.
he allow the Attorney General to answer the question?
I look forward to it.
Thank you very much, my colleague.
Mr. Chairman, I'll use only 5 more seconds. The fact is the Inspector General has released information that was secret to the object of our investigation with the knowledge of the Justice Department. She is not currently, in our opinion, qualified to investigate, and in fact has overstepped the line by delivering secret tapes to the object of our investigation while the Justice Department was slow rolling that discovery, and this is the ATF agent that was intimately involved with this. Okay. So I want you to understand, I have treated this Attorney General as a hostile witness because ultimately, while he comes before us saying he's going to clean house, no house has been cleaned.
Gentleman's time has expired, and the Attorney General will be given the opportunity to respond.
I'll try again. Gary Grindler was not provided with information, as you've described, intimate information about Operation Fast and Furious. He was not told about the tactics that were used there. The person who did the briefing was the acting head of ATF, and he has, I understand, testified before your committee that he did not, in fact, share that tactical information with Mr. Grindler. I note that Mr. Melson also briefed you, Congressman, about a month or so later, or before, I forget which, and he said at that time he did not share with you information about those tactics. So the notion or your contention that Gary Grindler was familiar with this or intimately familiar with this is inconsistent with what I think the facts are, and you take me to task for trying to assume what I know Grindler to have said. You have not interviewed him as well, and nevertheless you feel comfortable doing the same thing. With regard to the documents that you talked about, we have not withheld any documents that are responsive to the matters that you have asked us about. We have withheld information that pertains to ongoing investigations. That is the thing that might have limited our document production. But again, what we produced on February the 4th is unlike anything that any committee in any part of this Congress, Senate or House, has ever seen before. And I want to make clear, as we said in that letter, that is not precedential. I'm not holding, and I don't think any future Attorney General should be expected to do that, but given the nature of what we did in withdrawing that February 4th letter, it seemed to me to make sense to make an exception to what has been a long recognized rule.
Mr. Chairman, could the AG be allowed to fully answer, since it was pursuant to a subpoena, whether or not his answer about did he provide
The gentleman's time has
means he was
expired.
withholding or not withholding? He didn't answer
Does the
that.
Attorney General wish to add anything to
Mr.
his
Chairman, that would
answer?
require unanimous consent. I
The
withhold.
gentlewoman has not been recognized. I was asking the Attorney General a question. Does the Attorney General wish to respond any further to the questions?
I'm fine.
Okay. The gentleman from Virginia, Mr. Scott, is recognized for his question.